Did it hit record?
Yes.
Yes. Oh, it's going. Okay. And I got everybody in.
Yes.
Okay, you muted me.
Yes.
Okay. All right. Good afternoon, everyone. Welcome to this A Month of Service presentation of wills in advanced legal planning and why do you need it? My name is Nia Murray. I am the programs coordinator with Neighborhood Recovery Community Development Corporation. They can't hear. And we are one of the partners in the A Month of Service collaboration. Also included is the City of Houston's Department of Neighborhoods. And joining us today, we have joining us with the City of Houston's Department of Neighborhoods, we also have Ms. Cecile Carlson. Also on behalf of our presenting partner with Lone Star Legal Aid, we have Ms. Jessie Campbell, who's going to be presenting the information for you today. But included in our partnership, we also have the Earl Carl Institute, Texas Legal Services Center, Houston Volunteer Lawyers, Harris Central Appraisal District, and the Harris County Tax Assessor Collector's Office. And together we make up A Month of Service. And basically A Month of Service is the collaboration of all of our organizations coming together on a monthly basis, offering a variety of different workshops, resources, and information. That I'm getting feedback. He said the echo was really bad. Okay. All right, hope we're gonna work on that. How about me using them? Work with us, please, for just a second. We're trying to work through some technical difficulties here because we are actually hosting live from Shape Community Center located in the heart of Third Ward. So we want to welcome everybody and thank you all for allowing us to be here today. There's feedback on the Zoom. Yeah, let me use the mic and let's see if that helps. Okay, can you guys hear me? Is there feedback on Zoom?
No. I hear you. I can hear you very well.
No feedback?
No feedback.
Okay, good deal. All right. Okay, gotcha. All right. Well, we're gonna try this again. Welcome, everybody, and thank y'all for joining us this afternoon for today's A Month of Service presentation. I am Nia Murray. I am the programs coordinator with Neighborhood Recovery Community Development Corporation, and we are one of the partners in the A Month of Service collaboration. Also included, we have the City of Houston's Department of Neighborhoods, and joining us today, we have Ms. Cecile Carlson. Also on behalf of our presenting partner with Lone Star Legal Aid, we have Ms. Jessie Campbell. But included in the partnership, we have the Harris Central Appraisal District, the Harris County Tax Assessor Collector's Office, the Earl Carl Institute, Texas Legal Services Center, and the Houston Volunteer Lawyers. And together we make up A Month of Service. And just to give you guys a little bit of background about A Month of Service, it's the collaboration of all 8 of our organizations. We come together on a monthly basis and offer a variety of different workshops relative to asset building, asset protection, community empowerment, and the maintaining of generational wealth. So we are here today to provide you guys with some information about wills and advanced legal planning and why do you need it. In addition to that, I completely just lost train of thought. Oh my goodness. But in addition to that, we want to, much louder. Thank you. Okay. In addition to that, we want to make sure that we know that there are a lot of underserved communities that are out there that don't have access to a lot of information. They don't know where to go for available resources, for services that are available to them that can help with protecting their generational wealth, that can help maintaining their assets and help with building their assets. So we decided collectively several years ago to come together in a collective effort to make sure that we try to reach more people, create a larger impact, and get as much information out to the community as we possibly can. So we started doing these. We used to do the A Month of Service presentations in person only. And then due to the pandemic, we've had to go to the virtual platform. The virtual platform has allowed us to reach even more people in surrounding counties and throughout the entire state of Texas with getting a lot of this information out to people. But we're slowly trying to transition transition back into a hybrid kind of setting, because we don't want to lose the online people that still need the information, but we also want to make sure that we're going, staying in the community, engaging you guys, and making sure that you guys get this information as well when you weren't able to do that on a virtual platform. So we're here thanks to our hosts at Shape Community Center for allowing us to be here this afternoon. So we're live and we're streaming in person as well. So
as we stream, we ask you all to please give us your undivided attention. Okay, so any background noise, you might mess up the feed. So just listen, and I know you will, because we are honored to be able to make this presentation. So, and those in the back, keep it down, because we want to get the full bit of this presentation, right?
absolutely.
Okay, on behalf of Shape Community Center, take it over.
All right. Thank you very much. All right. So just to kind of go a couple little things really quick. The information that we do provide here today is for educational purposes only. It is not to be considered any legal advice. However, we do encourage you to reach out to any of our legal service partners, especially those with Lone Star Legal Aid, who actually have their intake workers and some of their staff members that are here. If you're interested in applying for any civil legal assistance, especially that related to estate planning and what have you, you have the opportunity to apply for their services while they are here today. So know that. If you are joining us on Zoom, please know that you have the opportunity to put your questions into the chat and or into the comment section, and we'll make sure that your question is addressed as Jesse goes through the presentation. In addition to that, we do record the session and send out the link of the recording to all of the participants that signed up, that registered. So you'll receive the recording along with a copy of the templates that she goes over as well. So we're going to make sure that you guys get that information as well. In addition to that, we do broadcast live on our social media platforms. We are streaming live as well on YouTube and sharing on our Facebook and our Instagram pages. So we do ask that you keep your questions to be as general as you possibly can. We do not want your personal detailed information to get out there to everybody to have access to. So we want to try to protect your privacy as best we possibly can. So make sure that you do that. In just a second, please. So we ask that you do not, divulge any personal detail information as you're asking questions. And then Jesse's going to give you a little bit more detail about the kinds of questions you can ask in addition to that as well. So do keep that in mind. Yes. Oh, I'm sorry. I'm so used to just rattling this off. I forget that. Yes, I do apologize. Yes, I will. Okay, with that being said, we are going to go ahead and move on into our introductions, and then we'll get right into the presentation. There's a lot of information that's going to be covered here today. The fact that it is being recorded, I do encourage you to go back and watch the recording because it will be a lot of information for you, okay? All right, that being said, Ms. Cecile, would you like to?
We can hear. Nia, we cannot hear.
Oh, they can't hear you.
Can y'all hear me now? Okay.
Yes.
Wonderful feedback. We're trying to figure out the situation here with the live streaming and doing this in person. Real quick, can you guys hear me? Okay, we're getting some feedback from, okay, perfect. I'll go over it real quick. My name is Cecile Carlson. I'm with the City of Houston Department of Neighborhoods. I'm an outreach coordinator and one of the partners here with a month of service. We bring education to underserved communities on different topics. Today, we will be talking about legal advanced planning and why we need it. We have Ms. Jessie Campbell from Lone Star Legal Aid. She is a wealth of knowledge. Make sure to pay attention. Make sure to ask questions. If you guys have anything that y'all want to write down, y'all got your papers here. And for those of you here in person and for those of y'all at home, make sure that you enter your questions in the chat. We're very thankful to the Shape Center for having us here, and we're thankful for everybody that's logging on online. We're thankful for our partners as well. I'm going to go ahead and pass it on to Ms. Jessie Campbell, and y'all enjoy this presentation.
All right. So I'm just going to confirm that sound sounds okay for everyone on the Zoom and everyone in person. Everyone can hear me all right?
We can hear very good.
Okay, fantastic. Well, good afternoon, everyone. Thank you for your patience as we kind of deal with all of this sound issues. It's always a little bit fun to deal with technical things when you're doing a hybrid in-person plus an online process. My name is Jessie Campbell. I am a supervising attorney with Lone Star Legal Aid, and I'm really excited for you to be joining us today as we present on legal advanced planning and why you need it. For those of you who are attending in person, let me introduce you to my staff that's there, which is Ms. Mel Pitts and Mr. Florian Neal. They are there to assist you should you decide to apply for services or any questions that you may have about our program. They'll be there after the presentation is complete. And so for those of you who are online, have no worries. We will provide you with all the information on how you can get a contact with us if you need to have contact with us. All right, so let's get started. Oh, I always don't have the button ready to go. All right, so first, a little bit more about Lone Star Legal Aid. We are a civil legal aid provider. What you would probably think of in terms of legal aid, that's us. We serve 72 counties in the eastern and Gulf Coast region of the state of Texas. So basically, the eastern third of the state. We go as far west as Waco, and we go all the way from Texarkana down to Galveston. And we also have 4 counties in southwest Arkansas where Texarkana is. We have 14 offices, including our headquarters here in Houston, which is where I am, plus the 13 counties in various cities throughout our service region. And it's just to say that if you know someone who needs assistance, there's in our region, we're here to assist. We are financially we are based on financial eligibility, which is going to be determining on the size of your household, your income, and your assets. Please don't ask me if you're eligible for services. It's actually pretty complicated math that we have to do. It doesn't take long for us to determine it. We just do need the help of a computer to figure it out. But our types of cases that we handle range from consumer, employment, family law, healthcare, housing, all the way to public benefits, estate planning, probate, just to name a few. Again, it's civil legal needs, so we don't help with criminal matters with the exception of record clearing, expunctions and non-disclosures, and we don't help with like traffic tickets, personal injury. Those are the types of things we don't help assist with. Otherwise, that's our contact information. Will be shared again later on. All right. As Ms. Nia already said, this is educational purposes only. Please do not take what I say today as a substitution of individual legal advice. If you have any questions about what to do in your personal situation, you should seek the counsel of an attorney if possible. Everyone has individual needs and different things, and there's usually a lot of facts that we need to know before we can answer their question. So with that, I also have to say that I am actually not allowed to provide legal advice until you are confirmed to be eligible for services. So as you frame your questions today, keep that in mind. If you are asking me something about your specific situation, how to handle it, I'm not going to be able to answer that. I can only answer it from an information, like this is what the law says, as best as I can to try to address your question. But I can't say, well, since you told me A, B, and C, then this is what's going to be happening today. Also, I don't want you asking those questions because, as Ms. Nia said, this is a public space. Not only are those individuals in person around all the people and your neighbors there, but this is also online. Those of us who are on the Zoom and those of us who are going to be watching this on Facebook, on YouTube, and the recordings that are going to be available for a little bit afterwards. So I don't want anyone sharing any private individual information anywhere on the internet where someone can take that and do something bad with it and harm you in some way. So please keep that in mind. Now, that being said, for questions, if you are online and either in the Zoom, if you're in the Zoom, feel free to ask your questions into the chat as we go. I am usually pretty good about seeing them as I present, and I will answer them if it's in the course of my conversation and it makes sense to put in the answer. Otherwise, for those of you who are watching this online via Facebook or YouTube, you can enter your questions into the comments. Someone will be monitoring them and they will ask them at the end. And same thing for those of you who are watching in person. I ask that you please hold your questions until the end, and then we will have an opportunity for you to ask questions at the end. All right, so there we are. That's all of the housekeeping. Let's talk about estate planning or advanced planning. So today's agenda, we're going to do some definitions. Then we're going to talk about the type of advanced planning. It's going to be broken down into planning for death, caring for ourselves in the event that we are unable to do so, caring for those in our care when we are unable to do so, either due to death or incapacity. We're going to talk very briefly about long-term care and what that is, and then the available resources that are available to you. All right. So first off, what is advanced planning? You already heard me refer to it as estate planning. Just be aware that those can be used interchangeably. It just kind of depends on the person. Advanced planning or estate planning, an attorney may say a different way, but they both mean the same thing, which is preparing and planning for death, caring for ourselves in the event of our incapacity when we are no longer able to do so. We have legally lost our ability to take care of ourselves. Caring for those in our care, that can also be referred to as family readiness. It kind of falls into two kind of categories, which is incapacity. When we are no longer able to care for ourselves, we are also no longer able to care for those who are in our care. We're unavailable. We may have been, we may be living in a different country, we may be traveling, and then we need to have those in our care be given some form of authority. And then, of course, in the event of our death, we are unable to care for those in our care. So we're looking at minor children, adults living with disability under a formal guardian. There's a guardianship already in place. And then adults living with disability under informal care. We haven't put in a permanent guardianship, but we are caring for them, and they may need to have that care ongoing when we are no longer available. And then long-term care, just to quickly define that, we are an aging society. Yay, good health care. We're living longer, basically. But as we age, there is a possibility that we will need long-term health care, where we may end up, a huge percentage of people at some point in time will end up in a residential facility where there's going to be assistance to help care for us and our physical needs, and as well as our medical needs. And so we have to prepare for that because there are expenses associated with that. How do you protect your property? How do you become eligible for financial assistance if you need financial assistance for that care? Again, that is going to be something we will talk very briefly. It's a little bit outside the scope of this presentation where we're focusing on death and incapacity. But for many people, because we are living longer, long-term health, long-term care planning is part of your advanced planning and should be something you are thinking about when you're doing the entirety of your advanced planning, because that's what advanced planning is, right? It's preparing for something that may or may not happen down the line. And then putting all of that decision making that you have made into a legally binding written document, right? So one of the first things that we have to think about when we're doing our advanced planning is the before versus the after. Advanced planning is the before. We are preparing. We are putting what we want, our wishes, what we want to happen to our property, how we want to be cared, who we want to care for us in the event of death and incapacity. So we are preparing, and that's what's planning. What happens after the person passes away or after they become incapacitated very much depends on the documents that exist and what a court may or may not have to do. And so when we're looking at the after process, that may involve a court. So when we pass away, the probate process is the court proceeding to settle the estate. So that's the probate after a person passes away, and managing the estate. The complexities of that process really depends on whether or not a will exists and what's included in the will. Now, I will say we're not going to talk about the probate process today, because we are focusing on the before. We are planning. The only time I will talk about the probate process today is to kind of explain a few things so that you understand what happens in probate, because it impacts your advanced planning. And so just be aware of that. Just be aware that we do have a sister, another part of this presentation that is going to be offered next week, that is going to talk about the after part on title clearing and things on probate. So just be aware of that. So if you are here for probate questions and probate purposes, please, I hope you stay, but also plan to come to that next session. Miss Nia, you had a question. You're muted.
Sorry. Can you slow down speaking just a little bit?
Oh, I'm talking too fast.
Members are having a hard time kind of keeping up. So just slow down.
Slow down. Got it.
Thank you.
A common problem I have. Thank you for reminding me that I was talking too quickly. I will slow down. I was worried about time. We started a little late. Okay, so probate again is the process when a person passes away. Now I want everyone, although I'm not going to talk about the probate process too much today, I want everyone to realize and don't be scared of probate. You will hear me mention it more than once today. Probate in the state of Texas is actually not that complicated of a process if you have a well-drafted, properly executed will. When you have a well-drafted, properly executed will, the probate process will take some time. And on average, it's about a year, year and a half for a probate process to complete. But the actual process in of itself is pretty minimal. The amount of time spent in court is 1 day. There's going to be a couple of documents that have to be filed with the court afterwards, but that's just going to be part of the course of what happens and it doesn't mean you have to go to court. It just means you have to file it. And then the administrator, I mean, sorry, the executor will be able to do what they need to do. We'll talk more about this as we get into the will, but it's pretty straightforward. The work of a probate, which is going to be how to handle the estate, which is dealing with the real property, houses and homes, land, selling it, transferring the deed, selling the cars, paying off debt, all the things that make up the probate process still has to happen. And so that whether or not there is a probate in place or not a probate in place, all of that still has to happen in some way. And so, but having the easier probate process makes that so much more smooth, makes it significantly less expensive. And so when we talk about why do you need a will before we even get to the will from the get-go, it makes the probate process less expensive, significantly faster, and will reduce the conflicts that may arise when there is no will. And so that's going to be the first step. A guardianship is the court process when we are permanently incapacitated and we are no longer able to make decisions for ourselves, and it is not expected for us to regain the ability to make decisions and care for ourselves. So that's a permanent incapacity. That does require a court proceeding to establish a formal guardianship. And so that is potential court proceeding for that. And then a suit affecting the parent-child relationship. So those are going to be minors, children under the age of 18, in the event of our death or incapacity. If we do not have something in place, there may be a lawsuit for conservatorship. That's the legal terminology in Texas. But the lawsuit is called the suit affecting the parent-child relationship. Most people would refer to it as custody on who's going to have custody of our minor children in the event that we are deceased or incapacitated, no longer able to care for our children. So those are the potential court proceedings. Again, it doesn't mean that you will be avoiding the court proceeding completely, but having the good documents in place just makes that process significantly easier. Okay. The second thing that I want everyone to kind of keep in mind is that this is an individual plan. Everyone has unique circumstances that impacts their advanced planning. It's going to depend on your family dynamics and the family members. Not every family is a happy family, unfortunately. There are estrangements. There are people who no longer get along with each other and they've severed connections with their biological family. And so they no longer consider them to be family members. Those are, but the law still does, so even though you are like, nope, I haven't talked to Bob, in 20 years, we are no longer, as far as I'm concerned, Bob is a stranger to me, but the court might be like, well, no, Bob's your brother. So, he still has legal rights as your brother, right? So we would need to so we would want to be thinking and planning for that in the event that Bob is going to be a factor. The type of property that you own. Do you own a house? Do you own real estate? Is it a mobile home? And if you are in a mobile home, do you own the land underneath it? Other types of property is the types of cars you may have, bank accounts, the personal property, what type of personal property? It's more than just your furniture and your clothing. There could be potentially valuable personal property such as jewelry, antiques, heirlooms. There could be highly sentimental property. It may not have an actual cash value that is high to the family member, it has it's priceless, and that can create conflict when more than one person wants this priceless family sentimental item. Who is in our care? Do we have a person who is a minor? Um, I already kind of mentioned that, but also our adults living with disabilities who are under our care. We have to think in kind about who is inheriting that property. If they are an adult and they are living with a disability and receiving government benefits, we need to know that because an inheritance may disqualify them from their benefits. So we would need to investigate a little bit more about who the heir is, what type of benefit they are receiving, and whether or not the type of inheritance that they're going to receive is going to impact those eligibilities. So that's the kind of case. And of course, your own health conditions. We're also planning for incapacity. So we would want to take into account the type of health condition we have, long-term health, in addition to what's currently happening. You are probably going to make different decisions when you are healthy and young versus when you're older and then you have an idea of what may be coming down the line, or you've received a prognosis of an illness and what to expect. So all of those are going to be kind of the factors that we're going to take into account. So that is to say that you and your neighbor may look very similar. You're married with two adult children, you live right next door to each other, exact same house, floor plan, everything. And your neighbor is like, "Hey, I got a will prepared. You know, you watched that presentation with Miss Jessie where she told you how to draft your own will. You can just copy my will. Don't do that because there's going to be all those factors that I just talked about that the attorney who drafted your neighbor's will is going to have taken into account in drafting the document, that you would not that your neighbor may not want to share with you to say, oh yeah, that's what's going on. So you can't just copy a will. Now, all that being said, there are templates for wills that exist, and obviously attorneys can help you draft your will, that do exist, that kind of cover some very common plans that people put into place. It doesn't mean that these will templates don't work for you. You just have to remember what I talked about in terms of that family individual plan need, because if you don't take that into account, then that will that you may have drafted using a simple template may not be what you need. And then remember, now you may have a properly executed will, but you don't have a well-drafted will because it doesn't cover all of the issues that may come up under that individual situation and still resulting in more complicated probate. So just kind of, again, keep that in mind. That being said, though, don't think about like, oh, this simple will definitely doesn't work because I said that. Only just kind of keep that in mind. Now, I did not mention this at the beginning. Today, we will not be talking about how to draft your documents. I will have a presentation next month on July 3rd, that will talk about how to draft documents and what you need to be taking out, like in the weeds, like what the paragraphs say, what they mean. And I'll talk more about that presentation at the very end. But just know that today we're not going to be talking about like how to execute your will, what kind of witnesses you need. So that we're going to cover all of that next month. Now you'll see this presentation covers a lot of stuff. You would be kind of like, oh, too much stuff, Jesse. So also, please keep in mind when to update. If you are here and you are thinking about whether or not you need advanced planning and you don't have those documents in place, today's the day. Today's the day that you need to think about your advanced planning. But most of the time, I always encourage people that as soon as you turn 18, and are considered a legal adult, you should have documents in place. Things can happen at any time, unfortunately, right? We hope for long, healthy lives, but unfortunately, it doesn't always happen. I am a firm believer that if you are prepared for Murphy before he shows up, then when he shows up and there's nothing for him to do, he just walks on past, right? So you just get him in place, have the peace of mind to know that you're covered in the event. Something does happen, but then you hope that you just don't need it for a very long time, if ever, for the capacity documents. But otherwise, once you draft your documents, you should think about when to update them. For most people, it is not always one and done. our situation changes. Remember, individual plan. So has your life changes, has your family changes, as your property changes, you're going to want to take a look at your documents to make sure that they still say and do what you want them to do. So changes in marital status. Have you gotten married, divorced, or widowhood, remarried? Children, that will include the birth of new children, the birth of children. Unfortunately, some of us do experience the death of children, but it also includes when your children age up, when they turn 18 years of age. The will that you wrote when they were minors may not be the will that needs to be in place when they are adults. Health changes, of course, as you have health changes, and then, of course, major property changes. Really, what we talk about when we think about major property changes, it's looking at titled property, things where there's a legal document that supports who owns the property. So mostly houses, land, cars, mobile homes, RVs. That's usually what we're thinking about in terms of major property changes. But that could also include obtaining new financial accounts. If you have if you started buying stocks, if you have, new investment accounts, it can include family heirlooms and you've inherited a family heirloom and now it's your responsibility to make sure it stays in the family. So it can include other major property. Again, only you know what is kind of happening in that situation. Choosing your representative, I go into great detail about this in the next presentation on drafting your own documents. But very quickly, it's very important to think about who you are choosing. Why we need advanced planning, as you will hear throughout this presentation, is to avoid conflict and to empower somebody to make decisions when we are no longer able to do so for ourselves. And so when you think about that, you need to be thinking about your representative very carefully. And one of the things that I say, oops, I clicked too quickly. Sorry, I just got, okay, sorry. Disoriented. But one of the things is that this can be a very emotional decision-making process for a lot of people. I advise if you are working with an attorney, have conversations with them about it because the person who is the best choice might not be the logical choice, might not be the obvious choice. I always joke in this situation. I'm the youngest child in my family, and so I always tease my brothers about having oldest child syndrome, and obviously I'm the baby and the favorite. For example, I am my mom's representative on her documents on the legal side of things. I am, and my brothers are like, oh, why is Jesse the one who got picked? And I'm like, because I'm clearly the favorite. I don't know why y'all keep asking mom that. But of course, my mom will say, well, no, of course that's not the case. She's like, Jesse's the lawyer. Let the lawyer do the lawyer things. This is work. Like, this is not something that is easy to do necessarily. And it's not hard, right? You'll have an attorney to help you through the process, but it is a process. As I mentioned at the very beginning, the probate process is managing the estate. It's calling credit card companies, paying off debt. Does someone owe you money? Now you got to send them a bill and get the money that's owed to the estate, writing a deed if the will is conveying the property to somebody. So in that case, my mom was like, yes, let Jessie be the one to do that because she's already knows what to do. Now, you don't need to have a lawyer to be your executor. It just happened to turn out in my family, I'm a lawyer. But but you're going to want to pick a person that is going to be able to have the ability to do that. And so that might not be the oldest child. It might not be your spouse. Right? It may be Bob, the accountant, right? So you got to kind of think in minds about what makes sense for the situation and to be able to do that. The other thing to consider is that remember, when this person is now going to be taking the reins, so to speak, handling an estate, making medical decisions on your behalf, making financial decisions on your behalf when you're not able to do so, something has happened, right? Something has happened to somebody they love. And sometimes the one that is what would be the next reasonable choice may not be the person who's going to be in the emotional state to be able to do that. Now, it varies household to household, family to family, right? People who've been married for 50 years, you may not necessarily want to pick your spouse because, again, they've been married for 50 years and they would have lost the love of their partner. I am hearing an echo. Can someone please mute themselves? We find the mute. Okay, thank you. Um, and so just kind of keep that in mind when you're choosing who your representative is. If you pick someone who would not be the logical choice in your family, have conversations with them. Remember, you're not going to be around to be able to explain why you chose a person over another, and people will create stories. Even adults, they'll be like, "Why didn't mom trust me? Why did dad feel like they couldn't empower me to be able to do this?" And it's not, because what you have made is probably a loving decision, a logical decision to make sure the right person's in place. But you need to tell the other person why they weren't picked and not them, because otherwise they're going to feel like they were not chosen for a reason and not because it was, hey, Bob's the accountant. Let Bob the accountant take care of paperwork, because you need to focus on grieving and living a new life without me around. And and I want you to be able to focus on your own self-care, your own needs, your family's needs, because my brother Rob is going to definitely be able to take care of all of the other stuff. And he's going to do it as a loving act for you, child, spouse, who are not able to do that. And so keep that in mind. I always advise greatly against any multiple agents. You don't want to have more than one person. One of the reasons why you are doing advanced planning, again, to avoid conflict. And if you have more than one person and they are not able to agree on what to do, then you're going to have a court come in and make a decision. And that's not really what we want. And so you don't want to be doing that. And in fact, in some of these instances, it's going to be unallowed. The court will not allow two people to serve in a role. So just be aware. And then have an alternate for everything I just said about your chosen representative. You're going to pick a person to serve in the event that that first choice is unable to serve. All right, so now we're going to talk about death. This does take up the most amount of time, so just be aware of that. So let's plan for our own passing. This is what it is, right? Which I understand can be a difficult topic to talk about for some people, even though we are logically aware we need to prepare for it, and it's coming down the line. It doesn't mean that we are really, enthusiastic about doing it, right? Or planning for it. So just be aware that I do have the type of personality that intersects a little bit of jokes into these things to try to keep not light, not to make it, funny, but to make it so that way we don't get too heavy today. So hopefully that doesn't offend anybody, but just kind of be aware that I do try to keep it a little bit up. And so that way we don't get too far down into preparing for what can be very difficult life events for us. So let's talk about property and what happens when a person passes away. This is usually me responding to people who say they don't need a will. So let me be clear on everything. Regardless of what I say after I finish talking about a will, everyone needs a will, period. No exceptions. Everyone needs a will. It is better to have a well-drafted, properly executed will and not need it than to need a will and not have it. Because remember, when you talk about the probate process, what happens with the court depends on whether or not a will exists. When there is no will, the court has to follow what the law says. That gets very complicated very quickly, depending on your family dynamics, the property that you own, and that can become very expensive very fast. You are required to hire an attorney to go to probate court. You cannot represent, the estate cannot represent itself. And so when you have an attorney coming in all the time, doing a lot of work, that gets expensive. And so, but remember, when you have a well-drafted, properly executed will, it results in one court appearance, a couple of court documents that need to get filed, but otherwise everything is done outside of the court process. And so it makes it significantly easier, much less expensive, without a lot of court intervention and some person, a judge that you don't know, making decisions about your property and your family. So, so hear that. Everyone needs a will. All right. So the first misconception is the only thing I own is my personal property. Yes. But what happens? What happens with your personal property? Is it oh, I'm so sorry. My nose just started itching. Who has the right to do with it? What's going to happen to your personal property? Is it going to be like we're going to open the doors and anybody who wants something can come in and grab it? Or is it going to be, well, what I really want is for certain family items to go to these individuals. So you're going to, you want them to go to certain individuals, maybe, maybe not, right? It's like these certain items I want to go to it. And then after that, I want an estate sale and, and then the proceeds split equally among my heirs, and then the rest of it donated to X charity, right? Something has to happen to your personal property. If you don't, if you are renting your home, who has the right to enter your property? And so just because someone's related doesn't mean that they have a right of access. And so who's going to be able to come in and take the property out of that space? And, so that the landlord knows who's allowed to be taking that property out of that space. So we still have to plan for personal property. You may not need a probate process with personal property only, but the will provides the instructions and so on what needs to happen. And so that way there's no conflict, there's no argument. Someone's going to be in charge of putting together the estate sale and making sure that everything gets done the way it's supposed to be done. And then if a probate is needed, then you have the will in place to be able to do that. Someone must have the authority to distribute property. So sometimes I get a lot of like, oh, they're going to sell the property anyways. Like, so we're talking about our house. The kids are going to get the house. They're going to sell it, or something along that lines, right? The thing is that if they're going to sell the house, who's going to be responsible for that, right? People have different opinions. Some people, this actually really happened pretty recently in an experience that I saw and that the right, which is that, so Bob and Susie are the heirs of the property. Well, Bob's like, you know what, let's just sell the property as is. We don't need to make any repairs or anything like that. We're gonna get, 100 grand for it. Let's just be done. Right. But Susie's like, wait, no, if we are willing to invest $10,000 or $20,000 into repairing the house, and getting it fixed up, put in the new roof that needs to be put it in, or just put in new flooring, we're going to get $150,000. That's a $30,000 return on our investment. I think we should do that before we sell the house. Who's right? Neither one of them is wrong, right? Like it's just a matter of preference on what you want to do and what's going to happen. So someone has to be given the authority to sell the property, make the decisions about how they're going to sell the property, and then of course how the proceeds are going to be split. Another thing that might happen is that right, let's take Bob and Susie again. Susie repaired the roof on that house about 2 years ago. She invested $15,000 to put in a new roof. Maybe you want Susie to get the first $15,000 of the repair of what she invested back, right? To say, hey, Susie repaired my roof, so I want her to get the first $15,000 of the proceeds. And then after that, I want it split equally between Bob and Susie. So those would be the types of things. In Texas, oral instructions around real property, land and houses have no um, enforceability. They are not valid. There's no way to sue on an oral agreement. So put it into writing so that way we know what's going to happen with the property. Title property has to go through some type of a legal process. This is where I get the kids are going to get it anyways. Yes, that may be true, maybe, because the intestate laws, which is the laws that apply when someone passes away without a will, tries to guess what you think is going to happen to the property. It assumes you want your property to go to your spouse and then to your children, and then to your parents. Like it makes a lot of assumptions, which may or may not be what you actually want. But that being said, it still has to go through a legal process. Just because there isn't a will and the law says, yeah, the property's going to go to the kids, doesn't mean that it's automatic. It doesn't mean that we now know who owns the property. When a person passes away and nothing happens, what we now have is a cloudy title. We don't actually know who owns the property. And the property and it can happen for multiple generations if more than one generation passes away without doing that. And so when you have a cloudy title, that can impact your ability to sell the property. It can impact the property value, like because you now have to, in some instances, if you're trying to sell the property with this cloud on it, then, someone may be willing to buy it, but they're going to pay you less for it because there's a possibility that someone down the road is going to come back and sue them for this property that they tried to buy that you didn't own. And so you have to go through this legal process. And what happens kind of depends, right? But if you have a will in place or other document in place, then it makes sure that the property passes and then we know exactly who owns the property and when the person passes away. I already mentioned that verbal agreements are not enforceable. So when that's usually the response when people are like, we have an understanding. We already agree on what we're going to be doing. Fantastic. Put it into writing because that way it's enforceable. Plus, sometimes people have conversations, and I'm sure this has happened to y'all before where you walk away thinking A, but that other person has walked away thinking B. So just because you both had the same conversation doesn't mean you actually had a meeting of the minds, is what lawyers will call it, where you actually agree. And so putting it into writing so that way no one is confused on what the actual agreement was. And the last thing that happens is that people are usually confused about co-owners do not automatically get the property when the other passes away. This is a misconception around community property. And so as a couple, you purchase a property together, that's community property. You each own an undivided one half of the property. So that's how it's written. And so a lot of people, if you are married, and your children are your spouse's children, then yes, technically under intestate laws, again, those laws, when a person passes away without a will, the property will pass to the spouse. So yeah, you may be correct. But what happens if you are a couple who've purchased a property together? You now each own an undivided 1/2% of the property that you own together, but you have children from a previous marriage. And you have children from a period. That's Bob and Susie, right? Bob and Susie are children from our previous marriage. Well, guess what? Veronica, second wife, does not get the property. The children do. That's what happens under intestate law. Now, what happens if you wanted your property? We're assuming we're a husband here, like, right? Or, well, I guess it doesn't matter. But what happens if you didn't what if you wanted Veronica to own the property? Because you assumed that when you co-own property together, that your spouse is going to get it. So you had assumed that Veronica was going to inherit the property under this unclear, inaccurate assumption. No, the children, Bob and Susie, are going to get the property. And so if that's what you want, you need to put it into writing. Now, you may want the property to go to Bob and Susie. That's okay too. It's your property. But again, easiest way is to put it into writing. And plus, again, that probate process will be a lot easier. Okay. All right. So what is the last will and testament? I've already said everyone needs one. So everyone, you're going to walk away knowing I need a will. A will is a legal document in which a person called the testator writes down what they want to happen to their property and debt. That's collectively the estate after their death and who they want to manage that estate. That is known as the executor. That's all a will is. It can be a pretty short, simple will. It can also be a long, complicated will, depending, again, on your individual situation and what it needs to happen. Now, lawyers, when they write wills, you will see that they have a lot of extra pages on there because we are planning for bad things. Like we are trying to anticipate problems before they happen and stop them from happening. So just kind of be aware of that. You can have a pretty simple will that is valid, that doesn't have all of the legalese, that legal language in it. Just know that when lawyers are drafting them for you, we are kind of anticipating potential problems down the line. And that's why we include some of these provisions in the will to prevent those problems from occurring down the line. A will covers only a probate asset. What is a probate asset? Those are the assets that the court gets to decide what happens. That the court has jurisdiction. They have the ability to make the decision on what happens to the property. Because again, probate's the court process. And so the easiest way to think about it is, what does the court not have jurisdiction over, which is the non-probate assets. It's probably the easiest way to think about that. So what are non-probate assets? Those are the property that's owned in a way that our state legislator, our folks in Austin, this is state law, our folks in Austin have said, this is how you own the property. And when you do this, it's going to pass according to other instructions, and it's never going to go into the court system. It's not going to be part of the probate. It's not going to be part of the estate. And so for most people, we're talking about three major things. Retirement accounts, 401ks, IRAs, those types of things. Those, you're going to go to the financial institution that holds the account, and you're going to name a beneficiary. And however it is, Bob and Susie, 50% each. Life insurance proceeds, you're going to go to the insurance holder, you're going to name the beneficiary, 50% Bob and Susie, or 100% of Susie, because we just like Susie today, right? So those are the things where we're just going to designate a beneficiary. Payable on death accounts. Now, this is the one that I want everyone to think about. When it comes to our advanced planning, one of the most common problems that I encounter in my practice is that we have beneficiaries, heirs coming to us. The only thing that they need to go through a probate court process for is to obtain access to their bank account, to the person who died's bank account. And that's the only reason why they need to go to probate court. And that is avoidable. You can't avoid that. So by having a payable on death account, and you're going to designate a beneficiary. So these are savings accounts, checkings accounts. You're going to go to your bank or your credit union, and you're going to say you want to create your account as a payable on death account, and then you're going to name a beneficiary. For all three of those, the retirement accounts, life insurance proceeds, payable on death accounts, when the person passes away, you're going to contact the financial institution, submit a copy of the death certificate, complete whatever form that institution requires, and they will disperse the property according to their policies when the instructions that you gave on the percentages of the beneficiaries. So for our retirement account, 50% it's going to go to Bob and Susie. Our life insurance is going to go 100% to Susie. And then our payable on death account, let's assume 50% to Bob and Susie. And so they will automatically disperse it in that way. Now, one of the things to keep in mind about bank accounts is that you want them to have access to the account. That's either going to be a payable on death account where they can get access to it that way because they will have inherited the money, because they have been named as a beneficiary, or you may want to create a co-owner of the account and for them to have access to the account. Now, this is important to know. Remember, just like the house, you bought a house together and you own half of it, each own half of it. The same is true for bank accounts. Just because a person owns the bank account with you doesn't mean they own 100% of the bank account when that person passes away. They only own their portion of it. So if they are a co-owner, they're going to own 50% of it. This is very important. If you're going to add somebody to your bank account specifically for the purposes of having access to the bank account, be sure that you know that they are trustworthy, that they're not going to steal the money, that they are going to do what they're supposed to do, just like anything else around the representative, because when you pass, they will have access to the accounts right away. But the reason why I talk about being sure that we have access to the account, either through a payable on death account or through some type of ownership of the account, is because bills still have to get paid. And so there's going to be final funeral expenses that need to get paid out. And if the estate is responsible for paying for that. So access to the bank account to be able to pay for the funeral expenses. If there's a mortgage on the property that needs to get paid, that needs to continue to get paid through the probate process. until the home is passed on, their utility bills and things along that lines while the probate is happening and until all the accounts are switched over and things along that lines. So you want to be sure that someone has access to the account to make it easier. But if there is no payable on death beneficiary, and the co-owner owns the property, so then they will have to disperse the property as well. So I know that was a lot. There is a possibility to own property as a joint tenancy with a right of survivorship. This is an agreement. We have now created the property in such a way that the two individuals that own the property, that upon the death of one, the survivor gets the property. So when I talked about our community property, that's standard. That's the default in Texas. The default is that when more than one person buys property together or owns property together, bank account together, whatever, that the default is that they own their proportion, but it's their individual proportion. They can disperse that any way they wish according to their will. That's the standard. That's what's the default in Texas. You can create a joint tenancy with a right of survivorship, which is then where, let's take our situation where we're married, Veronica's our spouse, and Bob and Susie are our children. The default is the 50% owned by us. We can pass to our children, but if you create a joint tenancy with a right of survivorship, then Veronica owns 100% of the property and we have disinherited Bob and Susie. Just be clear. When a joint tenancy with a right of survivorship, the survivor gets it. Whoever the heirs are, the other witness, the other things, the other people, whether through intestate, will, whatever, the other people who may have a claim to the property as a beneficiary have been disinherited. Now the property is owned by Veronica. So that is a possibility to do that. I always recommend that before you convert property to a joint tenancy with a right of survivorship, that you talk to an attorney about that. There can be some unintended consequences that people are not kind of seeing around corners for potential problems that may arise in those types of situations. Okay. Transfer on death documents. So I talked about the will. It covers probate assets, right? And so the non-probate assets. So non-probate assets are those three kind of things plus the joint tenancy. So we have our retirement accounts, our payable on death accounts, our life insurance policy, and our joint tenancies with right of survivorship properties. Anything else is considered a probate asset and will be covered by the will. So that's it in a nutshell. It's pretty straightforward. Now we have probate assets that will be covered by the will, typically. But the state of Texas has adopted two types of documents where if you execute these documents and file them, that the property will automatically transfer to the named beneficiary on that document upon death, bypassing the probate process. So these are probate assets. They normally would be covered by the will. They would normally go through a probate process. However, if you do a transfer on death document, then the property passes immediately upon death and you don't have to go to probate court to convey the title to these properties. So this is a way to avoid probate. Again, don't be scared of it. If you need it, sometimes it's the best way forward. But in many instances, for a lot of our clients and a lot of people, you can get by with a transfer on death document. So there are two things you can do using a transfer on death document. Real property, those are your houses and your land. You can do that through a transfer on death deed. This is a deed, just like a warranty deed, a quitclaim deed when you buy your house, right? So this is a deed. So it must be prepared. It must be filed with the county court in which the property is located in order for it to be effective. Then this will have then when persons, so we do a transfer on death deed and we give the house to Bob. Then upon passing, there'll be a recording of the death. Bob gets the house. He doesn't have to go to probate court for this. So that's important to note. Okay. We can also do it for our vehicles. That's going to include our cars, RVs, and mobile homes. And that's going to be known as a beneficiary designation of a motor vehicle. Now, for cars, I always kind of say, think hard about this. There is an expense associated with both of these documents. You have to file them. So there's a cost for the transfer on debt deed, depending on how long they are in Harris County, it's about $40. But for the vehicles, that can be upwards to $120. And so I usually say, don't do it for your car if you know it's not going to be your final car, right? And so, I am in my 40s. I just bought a new car. We didn't do a beneficiary designation of it because we assume within the next 10 years, 15 if we're lucky or something like that, right? That we'll be buying another car. And so we don't anticipate being our last car. So we didn't do that. Now, at one point in time, I did have an RV, and now people keep RVs for a long time. If you are one of those people who's lucky enough to have an RV and you're living the dream of retirement, traveling across the country, your RV is your home, right? It's basically a house. People own them for a long period of time. That might be something that you would want to do a beneficiary designation for because it is high value. The likelihood you're still going to own it for 20, 30 years, potentially. RVs last that long, right? And so especially when they're not, when they're towables as opposed to driving, they definitely last longer, right? So, so you may want to do it for that. Same thing with your mobile home. Mobile homes are like homes. And so if you would do a TOD for your house, then you would want to do a beneficiary designation for your mobile home. Those are treated like vehicles in the state of Texas. So that's where you would want to do it. It is actually, the process is super easy to transfer ownership of a vehicle after a person passes away, even without a will. So if that's the only property that would have to go and requiring the opening of a probate court, you can actually do that without going to probate if that's the only property. So doesn't mean you still have the will, but right, so you're going to do that. You still own the property, still your house, still your car. You can do whatever you want with it. You can sell it, you can renovate it, you can do whatever you want. The selling of the property automatically revokes the transfer on death document. And the person doesn't own any interest in the property. They can't take a transfer on death deed, go down to the bank and ask for a loan against the equity of a house that they don't own because they don't own the house. So just know that. And so you can change your mind. You can revoke it at any time. And you decide that, oh, I don't want Bob to get it anymore, so I'm going to go and file a revocation to be able to do that. Now, keep in mind, though, that you do have to file a revocation. You can't just say, oh, I don't want Bob to get it anymore. Or say, you know what? I actually want the house to go to Susie. I'm going to put that in my will because, as you see in bold there, a transfer on death deed takes priority over a will. Does not matter. You draft your transfer on death deed to Bob. You write a will afterwards, giving the house to Susie. Bob gets the house. You write a will to Susie, giving the house to Susie. You do a transfer on death deed later for Bob. Bob gets the house. Because they are effective immediately upon death, the will has no effect. The will can't undo that. So if you are planning on changing your mind or you're not sure, then you don't want to do a transfer on death deed. You want to put it into a will. And because you have to be sure you do that affirmative step of doing a revocation and paying for that, right? There's a cost associated with filing documents. And so then filing the revocation, so that way Bob doesn't get the house and Susie gets the house according to the will. So just be aware of that. And the other thing is think about, it may not be ideal in all situations, right? So, using some of my examples, things that you cannot do in a transfer on death deed is life estates. So we're married to Veronica. We want Veronica to be able to live in the house. Now, there actually is legal protections for Veronica, but you want to make sure that your kids know that Bob and Susie never liked Veronica, and I want to be sure they don't try to kick her out of this house. And so I'm going to make sure that it's clear that my estate, that my executor knows it's clear that I want Veronica to be able to live in this house as long as she is alive. So you're going to create a life estate. So you're going to put it into your document that you want her to have a life estate and that Bob and Susie don't own the house until she either moves out of it or passes away. Then you can't do that in a transfer on death deed, right? So that's a type of instruction. And so you're going to want to put that into a will not into a transfer on death deed. The other things are other types of instructions. Susie paid that $15,000 for the new roof. You want her to get the first $15,000 of the sale of a property. You want to do a transfer on death deed for Bob and Susie. Okay, you're trusting if they sell the house that Susie's going to get the first $15. And the, you know, but otherwise that's instructions. So you're going to want to put that into a will as opposed to putting it into a transfer on death, because that's not going to be enforceable and you can't write that into a transfer on death deed. So those are kind of things to keep in mind. If you're not sure if a transfer on death deed works for you, talk to an attorney about it. Explain what your goal is with the property, like how you want it to ultimately end up, like who's going to own it, how are they going to sell it, are they like what's the goal, and then the attorney can explain and advise you on what is the better path to go for, whether it's transfer on death documents versus putting it into the will. But remember, even if you do a transfer on death document, you still need a will. You still need a will. So don't forget that. So let's talk about trust now. I am not going to spend a lot of time talking about trust. Trusts themselves can be pretty complicated, and and usually when people want to ask me about trust, it requires me to know a lot more about why they're asking me the questions that they are asking to be able to have a conversation with them. A trust is an arrangement where one person or an entity called a trustee holds legal title to property of another person called a beneficiary. There are many types of trusts: living, revocable, irrevocable, just to name a few. You should discuss this with an attorney. What I will say at this point is that if the purpose of having a trust is to avoid probate because you have listened to a national expert talk about the doing a trust because you don't want to go through the probate process, that to me is not a good enough reason to put in a trust, to create a trust. All you are doing is changing the time and the work for it. Remember, a probate process is not complicated and not difficult if you have a well-drafted, properly executed will. When you don't have that, the probate process can be complicated, but you're not going to have that because you're going to work with somebody, with us, with whoever, to make sure that you have a will that's well drafted and properly executed. And that's going to minimize the need for probate. If that's the only reason why you're going to talk to me about doing a trust, is because you want to avoid the probate process. National experts talk about things generally, but probate, what happens when a person dies, estate planning law, advanced planning, that is state law. That's not federal law. So when you see somebody on a TikTok or on the Today Show saying, oh, you need to do a trust because believe me, I'm a lawyer. They don't tell you what state they're in. They don't tell you what the laws are in that state and why that's the case. In some states, yes, trust planning is what you have to do as part of your probate, as part of your advanced planning. Just like they will sit there in another state having their person be like, this is how you write your trust. For me, I'm telling you how to write your will because that is what has to happen in that state. That's not what has to happen in Texas. Now, all that being said, it doesn't mean you don't need a trust. You may need a trust. That's the come to an attorney, talk about what is the goal. Why do we think we need a trust? Is it a person that we have that we think that we have to worry about their ability to manage the funds? Are they on benefits? We got to protect their benefits. We're trying to qualify for federal benefits for ourselves. So we need to create some kind of a trust to be able to do that. Right? There may be a reason for it. But if the only reason is avoiding probate, that to me may not be a good enough reason. And so, again, you should talk to an attorney about it. So some bad news for everybody, which is debt survives. The estate, not the heirs, is responsible to pay the debt that is owed at the time of the death. So just be aware of that. Credit cards, medical bills, the estate's responsible for that. There's ways to work with that in terms of the estate is insolvent, that is that they don't have the money to pay the debt. There's things that we go through in the court process to let the creditors know, there's priorities, who gets paid first over the person next. So there's a lot of things that makes it complicated. I tend to not talk very much about debt when it comes to this stage because we are talking about a hypothetical. We don't know what debt is going to exist at the time of someone's passing because we have to know what exists at that moment in time. And if you're 30 and you're like, well, I got student loan debt, or I got, well, student loan debt gets just charged when a person passes away, typically. But like, I got a credit card debt of $20,000. I need to know how to handle that. Well, it could be though that that person is going to pass when they're 90 and that credit card debt was paid 30 years ago, right? And so we're talking about a hypothetical, but we have to be aware that the debt does need to get paid, and it does depend on what assets the estate owns and what debt is owed. What I talk about today in terms of advanced planning, that's something that we can anticipate, is that real property, as well as cars and vehicles, but our houses and our homes and our vehicles are inherited subject to the debt. That debt survives. So if there's a mortgage or a car loan on the house and car, if those do not get paid, there will be a repossession, foreclosure. So when someone is going to be potentially inheriting property subject to the debt, you may want to consider that as part of your advanced planning. And so, for example, if you have a mortgage on the property, but you don't anticipate that the person inheriting it is going to be able to pay for it, but you have a life insurance policy that can cover the mortgage, you may want to make sure that the life insurance policy is the beneficiary is the person who's also inheriting the house, and then let them know, hey, I'm going to give you the life insurance because you're going to have to pay off the mortgage. And I want you to use my life insurance to pay off the mortgage. If you want the executor to do that, to be sure that that happens, then you're going to want the beneficiary of your life insurance policy to be the estate potentially, and then with instructions to the executor to take the assets of the estate to pay off the mortgage. So different things. I do recommend that if you have that type of a mortgage on there, that you should talk to an attorney again about like how can you plan for that debt and to make sure that the debt gets paid. Otherwise, if there is no plan to pay off the debt, then know that the beneficiary will have to either pay off the mortgage or obtain financing to absorb the mortgage. Some financial institutions on a traditional mortgage may allow a person to just assume the mortgage as it is. I don't know. I'm not a banker. I can't speak 100% guarantee that that will happen. But just know that the heir will be inheriting subject to that. All of that is true for a reverse mortgage, except that you have to remember one important thing about reverse mortgages. Reverse mortgages are due 6 months after the date of death. 6 months. That is a very short amount of time. So if the person inheriting the property is subject to that reverse mortgage, right, they will have 6 months to figure out how they're going to pay for it. Either get financing to pay for it. You're going to come up with the plan with life insurance policies or other instructions so that way it gets paid off. But if the expectation is that the person that they're not going to be living in the house, there's no plan to keep the house, you may want to consider putting that into a transfer on death deed. So that way the heirs are able to have the maximum amount of time, the 6 months, to get the house sold and to sell it under their own terms, under their own conditions, rather than being forced to do it very quickly with a reverse mortgage company hovering with their 6 month deadline. And so again, all of these things are not, you're not taking my advice right now. Don't be like, oh, Jesse said, take the information, talk to an attorney about what's happening. Because again, it does depend on the situation. Might be some conversations to have with the beneficiaries. But those are just some examples of some strategies. Those aren't the only strategies that exist that when it comes to what to do with property that's going to have debt attached to it when you pass away. The next document, when we're talking about preparing for death, is known as a disposition of remains. It's actually a much longer title. It's designation of an agent for the handling of of remains. So, but it's a document that basically names the person who's going to make decisions for funeral arrangements. That's ultimately what it is. In the document itself, you can include your own instructions. If you have prepaid arrangements, you want cremation, you have burial ceremony requirements or wishes, you can put all of that into that document. But the key part of it, it names a person to be the ultimate authority on that. The primary purpose of this is to share your wishes on what you want to have happen, but also to avoid conflict. You know, in the aftermath of a person's passing, people are grieving, they're sad. A lot of conflict can come up, where it's like, no, we really want dad to have this, and no, we really want mom to, display it this way, right? Like people can actually have a lot of fighting around funeral arrangements. Um, there's a lot of counseling that kind of happens in that time frame. And so this is so those are really the two primary purposes of this document is to put down your wishes if you have any, right, that you want to write down, and then make sure that you name the person who's going to be the final decision maker on what will happen. Have conversations just like anything else about why you want what you want, explain what you want so that the person knows how to make those decisions going forward. So now we're going to move on to talking about the needs for documents for caring for ourselves in the event of our incapacity and potential unavailability, mostly though incapacity. So just so that we're clear, what is incapacity? Incapacity is when we are no longer able to make decisions for ourselves or care for ourselves. We have a mental health, cognitive illness that where we don't understand the world that's happening around us. We also could potentially be unconscious, and physically here, but mentally we're asleep, right? And so those are the types of things that we're talking about. There is some documents in here to talk about unavailability. You're just in your RV traveling around the country living the dream, but you have a house still here in Houston and you need somebody to be able to take care of the house. And so potentially you would have a document that can do that. But most of it, when I talk about this, I'm really talking about incapacity when we are no longer able to care for ourselves. So there's an in-between document. This is a step in between full capacity and incapacity and this is called supported decision-making agreement. So this is not a powered document in the sense that we're not giving somebody authority to make decisions for us. All this document is acknowledging that we may need some help, that we recognize that we have some cognitive decline. We may not fully understand everything and we need someone to come help us explain it in a way that we understand what's happening to protect us. And we know we need that protection because we may make a wrong decision because we don't understand or may not recognize a scam or things like that. Very useful document for children living with disabilities, with potential mental health disabilities who age up when they turn 18. They're able to care for themselves. They're able to do a lot for themselves, but they need some support. It's also very helpful for those of us who are aging. And so as we get older, some of us will experience a cognitive decline. We can still take care of ourselves. We can, pay our bills. We are able to, feed ourselves, go to the grocery stores. But, you're like, I got this phone call or I got this email, this text message. I am having a hard time identifying what this is. I don't understand what it is. And I'm worried and I know that there's something not quite right, right? So that's where you're going to have a supported decision agreement. And so this is a person signed by us to name a supporter to help us make decisions. The supporter does owe a fiduciary duty. That's a legal obligation to do what is in the best interest of the adult, the person who signed the document. And then so it's less restrictive. It's a good placeholder document if someone has been diagnosed with a form of dementia and and we know that dementia is happening, it's occurring, but we're in early stages, so most of the time we're aware of what's going on, we understand what's happening, but you're going to file this document with the bank, and so when they show up at the bank wanting to withdraw $5,000 to be able to send it to somebody they've never met in another country, that bank's going to call the adult and be like, the supporter, and be like, hey, adults here, we want to make sure that this is really what they want to be doing. This seems weird. It's out of character, so it looks fishy, so like we want to kind of double check that. So something to consider if you may or may not need it. Not everyone needs it, but it's something to have, and it's very helpful to have for those of us who need it. Statutory durable power of attorney. I'm going to get repetitive for a minute for a second. Everyone needs a will. Right? If you walk away from this, I hope like in 3 years, you're gonna be like, I went to that estate planning presentation with Miss Jessie. All I remember is everyone needs a will. So everyone needs a will. So you're gonna make sure that you have that minimum protection of having a will. You're gonna check your bank accounts. Make sure that someone has access to the bank account, either through a payable on death account or a co-owner, a trusted co-owner that will be able to manage the finances after passing. The third thing that you need to have minimum protection is a statutory durable power of attorney. So this document right here. So a statutory durable power of attorney names a person who makes legal and financial decisions when a person is unable to do so. This is the document that I am saying when you are unavailable, in addition to incapacity. So some people will go ahead and put together a statutory durable power of attorney and make it effective immediately. Be aware that this is the default. If you do not make it the other, it automatically is effective immediately. So what does that mean? It means that once you sign and execute it, the agent, the person who you have given that power of attorney to, can take that document, go across the street to the bank, and start handling your financial affairs in your name as your power of attorney. So that is what it means when it's effective immediately. Springing, that's when it's effective only when you are incapacitated and no longer able to make decisions for yourself. And that is determined by a doctor. It requires a medical appointment, a doctor making an assessment, and then making a determination that you are no longer able to make decisions for yourself. Ergo, now we're going to be doing now the power of attorney is effective. So there's no right or wrong here. It's whatever it makes sense for you and what you want them to be able to do. The reason why I talk about effective immediately is because you may already have somebody doing this. You may already have a person who's helping with your bank accounts, who's already, going and taking care of your legal affairs and stuff like that. And so this is a document that's effective immediately that gives them that power, and they don't have to do it individually at each individual financial institution or other institution, saying, here's the power, I need to sign it and give the permissions and things like that. This is already in existence and this will be effective. But again, there's no right or wrong, right? So some people are like, nope, I want to be able to make all of my decisions, take care of all of my stuff. I don't need any help. And some people are like, look, I'm already getting it. I want it to be effective immediately. So that's what the statutory power of attorney does. Be very careful when you are doing this immediately. The biggest red flag to think about is the person you are choosing. When I talk about this, sometimes people will say, I want this to be effective later at the springing when I'm incapacitated, because I'm not sure that I can guarantee that they won't do anything until, I want to make it effective immediately so they don't have to worry about the doctor's appointment. But I don't trust them. I want to be sure that they can't do anything until I'm incapacitated. I will tell you that that's not a timing problem. That's a choice of agent problem. You have picked the wrong representative. If you want to make it immediate because you want to avoid the need for the doctor's appointment, but you want that person to only do something when you are no longer able to do it, you have picked a person that you can't trust, right? Ultimately, that's what's being said. So if that's the driving factor to make it springing as opposed to immediate, as opposed to I just only want it to be effective when I want to be effective, then you've picked the wrong person because you haven't picked somebody that you can trust 100% with your legal and financial affairs. And if you didn't trust them when you were still able to make a decision to not do something, then can you trust them when you're no longer able to do anything about it? So keep that in mind. Medical power of attorney. So pretty much at this point in time, you will start to notice that we have two documents for different things, but that do the same thing. On one side, we have a document for our legal and financial things, and now we're going to do the medical side. So repetitive, Jesse. Everyone needs a will. Be sure your bank accounts are in some way that people have access to the money, either on payable in death or joint account holder. Third, everyone needs a statutory durable power of attorney to be effective, either immediately or springing. The fourth thing that you need to have the minimum protection is the medical power of attorney. And this is where a person will make your medical decisions to care for you in the event of your incapacity. It is only effective when you're incapacitated. As long as you have the cognitive ability to make your own medical decisions, your medical opinions will always, your medical decisions will always take priority. Also, if you make some decisions when you are cognitive and have the ability to make decisions, those will govern, even if after your incapacity, the medical power of attorney wants to do something different. So just also kind of be aware. So we're always being mindful of what we want when we are able to make our decisions. But that will be our next minimal protections. Here's some good news. Our statutory durable power of attorney and our medical power of attorney, those are known as statutory forms. They are which means that the folks at Austin have already written it for us. All we have to do is decide what powers we want to give them and execute the documents according to the requirements. So that's the good news about those documents. Next, we start talking about things that are good to have, recommended to have, but not necessary, not required. They're not going to be those 4 things you need to have for the minimum. Now we're going to talk about making it robust, like making sure we have all of our bases covered. So when we talk about power of attorneys, the durable power of attorney plus the medical power of attorney, really we're thinking about incapacity, hopefully on a short term. We're going to regain the ability to make our decisions. Medical power of attorney, we're in a car accident, we're unconscious, we need to have some surgery, someone needs to make decisions about what kind of medical treatment to have at that point in time. But when the person recovers, they're going to be able to make their own medical decisions again, right? And so we're talking about emergent, immediate needs of incapacity, trying to do that. When we're looking at permanent incapacity, there's no expectation that we're going to regain the ability to make decisions for ourselves, to care for ourselves. Then we're looking at a need for guardianship, the court proceeding. Some people will get away for a long time with a permanent incapacity using the power of attorneys. They can, but eventually they do run into a roadblock where an institution, whether it be medical, financial, legal, or otherwise, will say, nope, the power of attorney is no longer sufficient. We need a formal guardianship in place where a court is providing oversight, making sure that the person is being cared according to, the laws, and that there's fiduciary duty, that everything is being on the up and up, that type of thing. So a declaration for a guardian in the event of later incapacity is naming who that person is going to be. They may or may not be the same person in your power of attorneys. That's okay if they're not. Sometimes people will choose someone local for their power of attorneys because we're talking about immediate needs, and then they'll pick somebody who may not be local permanently because that's the person they want long term to be where they're going to live and be able to do that. Just like with the power of attorneys, there's 2 types. There is the person, which is who's going to be in charge of the care and health of the person. The estate, property, finances, legal matters. They can be the same people. They can be different people. If they are different people, be sure that there is some kind of expectation and understanding that they will get along, because just because they have different powers doesn't mean that they don't impact each other, right? So one of the things we're trying to avoid is conflict. And so if we're going to have different people, be sure they are people who are not going to be in conflict with each other. Something important to consider is that this is not dispositive, which means that the court is not required to appoint the people that you name. The court will take this into account, has a preference. And so Court's going to come and receive the document, and it's going to say, Bob is my first choice. All right, Bob, we're going to come and look at Bob and see if Bob can be appointed as the guardian. This is really how they're going to look at it. And it's like, oh, unfortunately, though, Bob, you have a criminal record that makes you ineligible to serve as a guardian in this case. So sorry, Bob, but you're not eligible. You can't serve. So now we're going to go look at Susie. Okay, Susie, let's take a look at this. Susie's like, I can't serve. I live in France. There's no way that I can serve, because they live in Houston. And so, okay, well, all right, Susie, unfortunately, you can't serve as the guardian either. So now we got to look to who's next. The court is typically going to look at next of kin. I mean, Bob, our strange brother recently, but that's not. So Craig, we're going to call him Craig. So Craig's our disengaged brother, who lives in California. Well, you don't want Craig to do that. You've been estranged from Craig for 20 years. You don't have any relationship with him. So in this designation of a guardian, you're going to say, I named Bob number one, I named Susie number two, but if for any reason they can't serve, I never want Craig to be my guardian. I'm disqualifying him. And you put that into this document. Now that is dispositive. So even though Craig is the sibling and he's next in line to serve as the guardian, he's the next of kin, court's going to be like, nope, she said no, Craig. So Craig is gone. We're going to now look at the next person that can serve. So that's how this document is. It's important. It is a document I recommend. It's actually quite simple. It's not very difficult it's only one page. And so only that makes it 2 pages. If you disqualify somebody, you have to have 2 witnesses and a notary. But that's just going into the form specifically. But otherwise, a pretty helpful document to have. If you're going to do documents, might as well put it in place. HIPAA release. HIPAA gets a lot of news coverage, but a lot of people misunderstand what HIPAA actually is. So HIPAA is the Health Insurance Portability and Accountability Act. It applies, what it does is that it protects private medical information, and it cannot be shared by those covered under HIPAA without the express permission. So those typically are medical professionals in some form, but lawyers, law firms are included under HIPAA as well, because we sometimes obtain medical information in the course of our representation of clients. We cannot share that medical information without the express permission of our client. And so now, if you share your medical story with your neighbor is not subject to HIPAA, and they can definitely go down the street and say, "Oh my goodness, did you hear the tea?" So just kind of be aware of that. HIPAA is only certain entities are covered under HIPAA. A HIPAA release gives that express permission. And so you want to have a HIPAA release, a minimum that includes your medical power of attorney and the guardian, the person you're going to name as your guardian if they're different people, because you want them to be able to get access to the medical information at any of your medical providers. And so that's what it does. You can add anybody else onto the HIPAA release. It's not uncommon for people to include entire families, like all the children and spouses on that. So that way they can at least hear the information. They can get the medical information if they need it. They won't be able to do anything with it because they don't have the power of attorney, but they will at least be able to obtain the information. And so it's quite useful and highly recommended that when you complete your medical power of attorney, you do your HIPAA. And the reason why is because that HIPAA release you may have signed with your primary care doctor is only effective for that primary care doctor. The one you signed with the surgeon before you went to the hospital, only effective for that surgeon. And so a general HIPAA release covers everybody. That way you're not potentially running into problems down the line. Having the power of attorney is not always sufficient for them to share the information. An advance directive, this is commonly known as a living will. I go over this pretty quickly, and in a kind of high level. Advanced directives are end of life decision making, the choice between whether or not you want to be put on life sustaining treatment or be allowed to pass peacefully. And so it's going to come into 2 situations, which is a terminal condition. That is defined as a person's expected to pass away, even with life-sustaining treatment, within 6 months. An example of a diagnosis that would be considered a terminal condition would be stage 4 pancreatic cancer, an aggressive cancer, right? So that would be an example of a terminal condition. An irreversible condition is one where we're not expected to recover, but the condition in and of itself is not terminal. You can live in that condition, but you need life-sustaining treatment to be able to intervene and to keep you alive. So if you don't intervene, it can become terminal. And so an example of that would be a coma. We can live in comas for a very long period of time, but we need nutrition. We have to be fed. We need liquid. We need water. And so the artificial nutrition is the life-sustaining treatment for a person in a coma, and they can live indefinitely in that position. That is considered an irreversible condition. For most of these advanced directives, there are two options, which is stop treatment, let me pass away peacefully, keep me comfortable, but please don't intervene. The second one is to use all life-sustaining treatment. Whatever needs to be done, please do that. Within that, you can provide specific instructions, which is that you never want to be placed on a respirator or things along that lines. Usually, I recommend that people talk to their doctors if they have a type of prognosis and for them to explain what the advanced directive would mean. Like, what does that end of life decision, what does that look like if they have a prognosis? Otherwise, we're really just kind of anticipating and planning for a very not potential, but hypothetical, right? When we're no longer able to make decisions for ourselves, we have written a document where we have kind of empowered what we want to happen in these situations. There is a possibility to write the document in such a way that you don't make a preference written down. You just want your medical power of attorney to confer with the physician and for them to make the decision. If you choose to do that, I actually recommend you do this anyways, that you want to have a conversation with your medical power of attorney on the situations, like explain why you want what you want, empower them with the information that they need. So that way, when they have to make this decision, they know what you would want. You may need to seek counseling and the service if you're a person of faith or you're a faith-based organization. They may have counselors available. You can also get secular counselors to be able to help with that, to be able to kind of have those conversations with these individuals, provide forgiveness if that's something that needs to be done. Because remember, what you have probably done is ask someone who loves you greatly to choose or not choose to end your life. And that is hard. That is a hard thing. So this document provides what your wishes are, what you want to happen, but have those conversations so that way they understand and can make the decisions if they need to make those decisions. Just as a note, this does not replace hospice care. If you are a person with a prognosis and you go into hospice and you have made a hospice plan, that plan will definitely take precedence over an advance directive. Just like with the medical power of attorney, as long as you are able to make decisions for yourself, your own decision making will govern, which is why the hospice plan takes priority over an advance directive, because you have made that decisions while you had the cognitive ability to do so. A declaration for a mental health treatment. This is something that not everybody needs, but if you are a person who needs it, it's important and you must consider getting it. So if you know somebody where this may be a need, let them know that this exists. This is a fairly new document. I want to say we're actually running up on to 10 years, but still a lot of people don't know that it exists. And so this is also known as a psychiatric advance directive, a PAD for short. It's a declaration for the person who's at risk of psychiatric hospitalization. So think of someone with schizophrenia. So that would be an example of someone who would have a psychiatric hospitalization. In advance, this person is making decisions on what kind of psychoactive medications they will take, convulsive therapy, and as well as emergency mental health treatment. It does require a judge to make a determination to do that they are incapacitated, that this document goes into effect. Unlike the other documents, this expires. It has to be reissued or re-executed every 3 years. So, but a very useful document for those individuals who need it. So now we're going to talk about those who are in our care, planning for that. This is actually a lot easier because a lot of it has already been covered in the other documents. So our last will and testament, we can actually put it into our will who we want to care for our minors in our care, and as well as the adults in our care. The trust can be created in there if there's a trust that's needed. So a lot of that can get covered in the will. Typically, the surviving parent becomes the primary custodian, the conservative, and that's pretty common. But sometimes, both parents are not available, or both parents are deceased, and so you can in the will name the alternate conservator or person who will take care of the minor children in the event of death. You can also do it in your designation of a guardian in the event of later incapacity. So you are a guardian yourself of a person. So you can name a successor, just like the declaration of guardian in the event for ourselves in the event of later incapacity. The same standards apply. You can. It's a preference. If there's someone who's named for a disqualification, the court will take that into consideration. This one is a new document we haven't talked about, but it's the one that's really useful. It's an authorization agreement for a voluntary adult caregiver. This is the one that actually is what you would want to have in effect if you were unavailable. This is not an incapacity document. This is an unavailable document. And so it gives a non-parent. Obviously, parents have legal rights to their children, and they can do a lot of things that you can do as a parent. So non-parents, though, that includes grandparents. Grandparents don't necessarily have legal rights to do things. That it gives a non-parent the authority to care for and make decisions for a child without the court's permission, without having to go to court and say, "Hey, can I, take care of my grandkid or my nephew?" Right? So various permissions include consent to medical treatment, getting insurance, enrolling them in school, consent to extracurricular activities, obtain a driver's license, permission to get a job, apply for and receive public benefits, obtain copies of federal and state personal identification document. So that's the type of things that that this document could have. Really, really important document if you are a person who needs it. You can do it effective immediately, right? Like if you have a grandparent, our village of people, and a grandparent is the one picking up the kids from school and doing a lot of that kind of stuff. You can have it, even though the kids come home to you. You can still have this for your grandparent. You can be that way, and it also could be a situation where someone is not available. When I was growing up, my dad worked overseas. He worked abroad frequently. And so like this would be a document that he and my mother could sign if they wanted me to travel with a family friend to go visit him in the country that he was working in. And so that would be the document that they would sign to allow me to travel with, I'm sorry, not travel, but because there's a different document for that. That's next. But it would be a document that he would sign for like his grandmother to help me, do what I need to do, right? So these are really, or a neighbor, like it can be anybody. So this is a helpful document if you think there's a possibility that you will not be available or not, not in the country for, that you can name somebody to be able to do that. I always recommend that this is a preparation document. So you want to put all the information around the family into a family binder. And so that way the person who is the non-parent has access to the information that they need. If there is a court order involving the custody and conservatorship of the children, then you need to consult an attorney because you can't just unilaterally make these changes when there's a court order that defines the roles of the parents already. Now we're talking about the travel authorization. So the other document, despite the fact there was this whole list of things it does not actually allow you to travel with somebody who is not your parent. And so this is also known as a parental consent to travel form. This is the form that you would create for a non-parent to be able to travel with their child to wherever. As promised, we are now at long-term care planning. Again, this is itself a pretty complicated topic that can take a lot of time to discuss, but long-term care planning includes becoming eligible for benefits such as Medicaid and protecting assets from creditors, including the Medicaid Estate Recovery Program. So very briefly, so that we are aware, because this is long-term planning. We are trying to protect our estate for our heirs. We worked hard for everything that we own, and we want to pass the benefit of everything we acquired to our beneficiaries. And so we don't want the money to go someplace else, right? And so the Medicaid Estate Recovery Program is a program that says that if you go into long-term care and you use Medicaid benefits to cover that expense, then the state has a right to come back and recover its costs, recoup its costs. That's the Medicaid Estate Recovery Program. And so there are things that you can do to prepare for that, to plan for that. And so when it comes to real estate, your houses, your land, there is something commonly known as a Lady Bird deed. I wrote estate, it should be deed. It's actually an enhanced life estate, that's the legal term for it. Or a transfer on death deed will also protect the property. It's really a question of whether or not eligibility is a question, is an issue. Most of the time, a transfer on death deed will provide the same and all the protection that is needed. However, there may be a need where a ladybird deed makes sense and we would want to do that instead. I highly recommend that we always talk to an attorney about that. There's a lot of unintended consequences when it comes to a ladybird deed, and so we don't want to do that unless until we know it is the right step forward. When it comes to income, as we are receiving income into our household, you can only make so much money in order to qualify for Medicaid. And so what can happen is that there's a couple, one spouse continues to work because they need to bring income into the household, but the other spouse needs the Medicaid benefits. And that one income is enough to disqualify them from Medicaid. And so for income, there's what is known as a qualified income trust, commonly known as a Miller trust. That is an irrevocable. That means once it's put into place, you cannot cancel it. It will exist in perpetuity until it no longer is needed, which is upon death. And but the income comes into the household, into the Miller trust, and that makes the household eligible for the spouse who needs the benefits to now qualify for Medicaid. Again, this is pretty complicated. If this is something that's on the horizon for you because you know there's family history, that we know it's going to be coming up, that is something to consult with an attorney on to be sure you're making the right plan. Okay. We're pretty much done. So upcoming programs, as I mentioned at the very beginning, we have clearing title to inherited property. So for those of you who came here hoping to learn more about probate and what to do because someone you love has passed and now we're trying to figure out what to do after the passing, please go attend this one where my friends and colleague are the one who present on it, and they will be able to answer some of those questions that you may have on clearing title. Then, for those of you who are not in person and are watching this online and are interested in applying for services or need services, we will have a clinic. Lone Star Legal Aid, Earl Carl, and NRCDC on Saturday, June 14th. Where we can assist you with some of those needs. Registration is required. Please don't just show up. Please register. Ms. Nia will probably talk more about that. But she's ultimately the boss here. But there is that upcoming clinic available. And then there is, as I mentioned, on Thursday, July 3rd, I will be presenting part 2 of this presentation. Today was kind of talking about what the documents are, why you need them. But part 2 is like, all right, Jesse, I got it. And I think that these simple documents, all I need is a simple will. I've heard everything you say. Simple will is what I need. And in part 2 on July 3rd, I am going to go through and talk about how to draft your own document. And even if you're not going to use the simplified forms, it's still a great thing to attend because it will tell you how you can draft your own documents and draft your own will and your own transfer on death document. And then we will talk about how to draft everything else. And so come to that one, completely different from this one. Think of it as a part 2. So that is my information. If you want to come to me and if you think you are eligible for services, that's how you can apply. For those of you who are in person, you can definitely talk to Miss Mel and Mr. Florian who are there to assist you. And so that's it. I think I'm slightly out of order, but that's everybody else that is in the partnership that you can reach out to. But I always try to end with a funny cartoon because again, heavy topic. I try to make it fun. So this is our couple here, and I think it's the husband who's got the coin, and it says, "Heads, we create an estate plan. Tails, we leave it to the courts to decide. Let's hope it lands on heads." All right. So I'm going to allow questions. I'm going to look real quick to what was typed in, but anyone who has a question, feel free to type it in, unmute yourselves and ask. Ms. Nia will probably manage that right now. So let's see. So I did have a question about going over what probate is. I'm hoping that the little bit I kind of covered, it really is outside the scope of this, but just as a reminder, probate is the court process. When a person passes away, that you have to go to court, and probate is that process. And it's the administration of the estate, which is to pay the debt, identify what the estate owns, what is owed to them, collect money that's owed to them, pay the debts, and then transfer the ownership according to the instructions in the will. If there is a will, and if there's not a will, then what the court instructs them to do according to who they determine is the heirs at law. And so, and the complexity of that process depends on whether or not you have a well drafted, properly executed will. So that is what the probate process is in a nutshell. More detailed questions, I recommend you attend the session next week to hear more about that. Let's see, I have a question about costs. I can't tell you how much things cost. I am a legal aid attorney. I do things for free for people who are eligible for my services. Again, it's financial eligibility based on the size of your household, how much money you make, and how much assets you have. It's a little bit complicated, so we have to make a determination of that. But how much it costs outside with the private bar, those are individuals who you would pay for services. That's going to depend on the complexities of your estate planning, what you need, what kind of documents you're going to have, the experience of the attorney. So those are going to be the things. So unfortunately, I cannot answer the questions of how much it will cost, nor can I recommend any individual attorney in the private bar. I will let you know that if you are going to seek assistance from the private bar, you'll see the fourth item there. And Miss Nia is going to send this all to the people who registered, so no one needs to frantically write this down. But Houston Lawyer Referral Service is part of our partnership. They are a private attorney referral. That's where you can find and call them up and ask them for referrals to people who do this for a living and get paid for their services. And I think those are all the questions.
No, there's a couple.
Did I miss one? Oh,
Jesse, we do have a couple of questions here.
okay. Yeah,
Wait,
yeah.
I've got one that was just given to me too.
Okay. I'm gonna drink some water.
Jesse, can you hear me okay? Okay. The question is, if a deceased person owned property in a different state, example, Texas, Louisiana, New York, will one will be sufficient? If a deceased person owned property in a different state, will one will be sufficient and applied across all states, or do you need a separate will per state?
It depends on the state where the property is located and what they will accept.
Hold on, Jesse.
Oh,
Jesse, say something?
it depends.
Okay. Okay. All right. There you go.
All right. How's that for a lawyer answer? It depends. It depends on the state. Remember, we're talking about state law, right? What Texas requires is going to be different from Louisiana. It's going to be different from New York. It's going to be different from Alaska. So it depends on the other states. Some states will accept a will written in another state, and they will bring it in as like an auxiliary probate administration. But remember what I said. Every state has different probate laws. And so if you have property in another state, I highly recommend that you contact an attorney in that state to find out what would be needed for advanced planning to make sure that that property is handled according to that state's law. I can't tell you what New York requires or Louisiana. I can only tell you what Texas does.
Okay, we have another question.
Let me, oh,
I'll repeat it. Go ahead. What's the advantage or the pros and cons of having a will put inside of a trust?
think you actually made it in the opposite way, to have a trust inside of a will. I think everyone needs a will. The thing is that for me to be able to answer that, I need to know what the goal is, right? And so I can't answer that question. Just like when I talk about a trust, right? When we're talking about a trust. So I think what you're talking about, I think what the question is that a trust includes the disbursement. That's what a trust is, right? Like it's the property is owned by the trust, being managed by the trustee. So it's, and they're going to disperse the property, manage the property according to the instructions in the trust document. That's that's what it is, right? And so to me, when you're asking that question, you're basically being like, what should I have a will versus a trust, right? Because the trust will include the disbursement instructions that would be what would be included in the will. And so I think it ultimately comes down to what is the goal, and but regardless, no matter what, you still need a will. But it depends on your goal, depends on your assets, it depends on what we're trying to accomplish with our trust. So I don't know if I really answered the question, but I don't think I can give you like a pro or a con between that. Usually, some trust would probably be
She was
helpful
just
when you're
trying to
talking
finish.
about like who the beneficiary is going to be. Like if definitely if they're minors, we would minors usually property have to be held in trust for them. But it could also be very beneficial when somebody that like lives is living with a disability to be able to manage the property on their behalf. High wealth, usually a lot of people who are doing trust planning is a way to kind of try to minimize estate tax. Those are just some examples. On the CLE question, while the bar no longer covers CLE, you can still count this as self-study. So depending on how much self-study you've already done, you can always report it as self-study.
Okay. Um, there was another question. No, you can ask it. If there is no will, does it still need to go, you still need to go through the probate process?
Mm-hmm. The probate process has to happen for a lot of people, whether or not there's a will. So the will is not what determines if a probate happens. The probate is going to happen, likely. Something has to happen. Remember, going back to my slide, something has to happen. You have to transfer the ownership of the property. You can't just say, all right, Bob owns the house now. A document has to be written. Someone has to have the legal authority to write that document. And so whether it's a transfer on death deed or it's in a will. So, or if there's no will or transfer on death deed, then the judge is going to have to decide who owns the property, and do that. There's some alternatives, which is what will get covered next week. But from my perspective, when we're talking about advanced planning, that's what we're kind of talking about. As a lawyer, it's really important that I always start from the position of the worst case scenario, the biggest level of problems that we're trying to avoid. Just because alternatives exist doesn't mean you prepare and plan for an alternative. We think we might be able to do it in an easier way. So I'm not going to write a will because I think this other thing's going to be available. You don't know that. You actually don't know that. We're talking about a hypothetical. We don't know exactly what's going to be the situation, and a court still needs to get involved. Even if an alternative exists, that might not be an option. We still might have to get the court involved. And so when I come from this from I assume a court has to get involved. I assume that the alternatives will not apply when we're talking about advanced planning, when we're thinking about before. And so when I come in assuming that your estate is in such a way that what you own and the people who are going to inheriting the property is in such a way that I automatically assume it's going to require a probate, then you're going to want, that's the reason why I say you want a will. And so, because it could be if you have no will and they're like, well, who owns the property? Someone's going to be like, you got to go to court and tell me who it is because I'm not going to accept this other document. Right. And so I hope that makes sense, right? The probate is something that may have to happen. Whether or not you have a will doesn't determine whether or not a probate happens. It just determines whether or not the probate is complicated.
Okay,
Pretty much go off what the other person said, will versus trust, but I did pay for the taxes for it. I know they mentioned in the house, law purchase support, I don't know the test of it. If that house purchase, let's say, was 500 and that was at 200, how does that difference in tax support? And
it does, has nothing to do with the property taxes. Because once a person passes away, whatever exemption that they have goes away. Jesse, she was basically asking, the will, kind of piggybacking off the other question about wills versus trust.
Mhm.
And if the property is owned in a trust, what happens with the property taxes? No, I'm trying to. So you're asking if the property is owned in a will, is inherited or passed on in a will versus a trust, what happens in relation to the property taxes? That's what she's asking, Jesse.
Okay. The property taxes apply to the person who's living in the property, right? So whether or not it's owned outright or if it's been transferred into a trust, and property taxes in a trust, way outside the scope of this, but in very short terms, the trust has to be written very carefully to guarantee that the person who's living in the property can claim the property protections as they would if they were not, if the property was not owned by the trust, because the trust owns the property,
Okay,
right?
she's speaking about property tax value. That's another workshop. We have a
Yeah, that's a
property
different
tax workshop that we do with the Harris County Appraisal District and the Tax Assessor Collector's Office, that they can probably go into a little bit more detail as it relates to the value of the property. But from my understanding, the value is what the value is without the exemption when the person passes. So say, for instance, you've got a house that's $200,000 that's in a current trust with it, or a senior owns or what have you, and they have an exemption. When their exemption goes away, whatever the value is without that exemption is what the new person is going to now inherit it at that rate.
Yeah, so property, so when a person passes away, there's some like weird exceptions, but for the most part,
They're gonna
like
they're gonna owe the taxes on what the value is without the exemption at the current time that they passed.
so there is what is known as a step up in value, right? So when a person inherits
Are you talking
property,
about inheritance
revalued.
tax? Okay, totally different thing now. Inheritance tax. That's
Inheritance
what she needs to know
in a
about.
trust,
Inheritance tax.
that's outside the
Is
scope.
there inheritance?
Right. Like I don't want to spend a lot of time talking about things that doesn't apply to a lot of people. So inheritance, when we're talking about the estate tax, we're talking about an estate that's worth over $1 million. So if you have an estate that's worth over $1 million, I'm going to highly recommend you go talk to an attorney. So because we're talking about high value estates, and there's a lot of nuances when it comes to the estate tax.
If the estate itself is not more than a couple of $1 million, then it doesn't really apply. If it's more than 1 million, it doesn't apply in Texas. So the
Nationally,
estate
no,
has to be over a certain dollar amount in order for inheritance taxes to apply. Is that what I get?
For the federal estate tax, it's federal.
You
Like
need
it's
to-
over, like yeah, it's over $1 million. I have to look up the.
Hold on, because she's answering the question, but you guys can't hear. Okay, repeat that again, Jesse.
Oh yeah, no, it's the federal estate tax. Texas does not have a state estate tax. Only if so the only tax that would apply in Texas would be the federal estate tax, and the estate has to be valued at over $1 million before even. Actually, it's more than that. I want to say like it's five. Like I have to double check it, but like it's high value estates. if you're worried about the estate tax, chances are you can afford an attorney to kind of talk to you about that. Very different estate planning when we're talking about high value estates.
Yeah. It's not planning, the June 14th. Mute that real quick. The June 14th Todd Clinic. You can't. Oh. The June 14th event is a Todd Clinic where we're gonna have attorneys that are gonna be there to help you with answering questions as it relates to your Todd. If you wanna have a transfer on death deed created, they're gonna be there to help review it, answer the questions, help you fill it out, you know, things like that. Have it notarized for you and then get it filed for you on the same day. So that's what that's for. It's not an estate planning workshop.
However, my team will be there to accept applications for people who need more assistance than a Todd. But if you're there in person, talk to my team there. But you still have to be
Jesse, if
registered to
someone
it.
is eligible for a different service with Lone Star Legal Aid, can they also then be eligible to go ahead and get their estate planning or other documents done if they are already applied and have been qualified for Lone Star Legal Services?
Yeah. So you can either if you're already a Lone Star client, then just let whoever's there talk to Mel and Florian and let them know who you are, and they'll be able to go through the process to get started. Mm-hmm.
Yeah, that's them in the back there. Yeah, that's them. They're with Lone Star Legal Aid in the back there. Yes. In order for a will to be valid in the state of Texas, what needs to be included in the will?
So they want to come to July or watch the recording from last month. I do talk about what the requirements are in a will. It's just that it's so much information to cover in this presentation plus in that. But it's, you know, it depends on your situation ultimately, but otherwise it's just that your will has to name an executor, identify what you want to happen with your property, name an executor, and be properly executed with two witnesses, and but and well, make it easier a notary.
So this presentation, the wills and legal advance planning, it's kind of in two parts. So where she goes over the information about wills, what makes up an estate plan, and then all the documents. The second part that she does is actually going to be August, Jesse, not July. We take off for the month.
That's right.
July.
I forgot we take July off. I'm sorry.
And so it's going to be August the 7th. So August the 7th, she goes through and tells you how to draft your own will and how to draft your own estate plan or your Todd. So, you know, she'll go through that in a little bit more detail. However, we did that one last month. So when I send out the recording of this presentation, along with those other documents she went over, I'll include the link of that recording so that you can watch it if you wanted to go, if you wanted to, you know, take a look at that as well. Are there any other questions? Who pays for the probate application?
The estate.
The estate.
Just be aware.
It
So
comes
just
out
to
of
kind
the
of quickly
estate.
answer the unspoken question that's
But
probably being asked.
if the person pays for it, they can get reimbursed by the estate.
The estate's
Because you don't
responsible.
have access to it yet without going probate.
Right. Which is why I talk about having access to the bank accounts.
Is it all possible for what? What happens, or can you explain what it means when the estate is solvent?
Oh, insolvent is what I was. It's basically
Insolvent.
when they're insolvent, they're basically completely bankrupt. They have no assets. There's no income for the estate. They don't own anything except for what would be considered protected assets like a home and a car or something like that.
So what about if all expenses are paid after the probate has been done, all expenses have been paid, and then there's no money left?
I don't know what the question, I don't know what the question is asking. Then
That
unfortunately
was
there's
the question.
to inherit.
Is it possible that once you open probate and then you paid all of the bills and everything for the estate, can the estate end up with no assets or no funds or anything like that whatsoever?
Yeah, that's possible. There are people who are
Yes.
upside down, right? There are people who owe more than what they have. So it is possible that it gets zeroed out. Yeah.
Is that answer for you guys? Oh, okay. All right. With that being said, I think we are all done for today. Jesse, I want to thank you, and I want to thank all of the participants that have logged in, that have kind of sat through with us and working out our technical issues. We do appreciate your patience and your time. Thank you guys for showing up, for continuing to participate and support the A Month of Service collaboration. Again, next week's presentation is going to be about clearing title. So what happens in the probate process, what happens after the person passes away, and what happens with inherited property. So that's going to be next Thursday at 1 p.m. On Tuesday, definitely invite you guys to join us on Tuesday over at the Alice Young Library. We're going to be having a title fraud and deed scams presentation. That is a very big problem that's happening in a lot of communities where title fraud is happening and people are losing their property and false deeds and claims are being filed against people's properties and it's being stolen. So definitely want to join us for that if you guys have not already registered for that. But I will include a flyer of that information along with the TOD that's scheduled for next Saturday, again with the email to everybody that's registered. For you guys that are here in person, the packets that you have, the flyer for each of those that she talked about, they're in those packets that we distributed as well. So thank you all very much this afternoon for continuing, again, for joining us. We hope to see you again at future presentations. We hope you all have a wonderful remainder of your afternoon. Continue to stay safe and have a good one. Thank you, Jesse.
Thanks, everyone.